Okay, this is a presentation on Access to Information Act requests that I originally gave to a group of lawyers in Quebec in 2022 that I have updated for today's video. What I will be covering today are Access to Information Act request versus Privacy Act request, exemptions to disclosure, how to submit Access to Information Act requests, why requesting internal information during the processing of a visa application can be useful, delays that are currently occurring in receiving information from Immigration, Refugees, and Citizenship Canada, as well as general policy requests. While the presentation that I originally gave was about an hour long, I'm hoping to condense it for this YouTube video to about 10 to 15 minutes. So the Access to Information Act is a piece of federal legislation that gives Canadians, permanent residents, and individuals present in Canada access to information in federal government records subject to certain limitations. In the immigration world, we tend to use the term ATIP to colloquially refer to access to information requests, but that isn't actually a term found in law. It's actually the ATIP is sort of a combination of the Access to Information Act and the Privacy Act. And I'll get to the Privacy Act in a bit. The Access to Information Act applies to requests also from those who are not in Canada, or those who are without status in Canada, who have a representative who can make the request on their behalf and obtain consent from the person whose information is being requested. It is possible to submit Access to Information Act requests to many government departments, including Immigration, Refugees, and Citizenship Canada, the Canada Border Services Agency, Service Canada. It's possible to request guides, memos. It's possible to request email correspondence amongst officers, briefing notes, as well as, of course, an individual's personal immigration application. The Privacy Act provides Canadian citizens, permanent residents, and any individual present in Canada with the right to access their own personal information. Canadian citizens and permanent residents who are not in Canada do need a representative in Canada to submit these requests. There are several exemptions to disclosure, and what I have produced in this slide is the reasons why information was redacted and the frequency that that reason was cited in an ATIP. So what won't be disclosed is third-party information regarding other individuals. For those submitting Access to Information Act requests, it can accordingly be important that if you're requesting information about multiple people, to obtain consent to the information being disclosed for all those people. It also includes information that could reasonably be expected to threaten the safety of individuals, as well as information that pertains to investigations or that could be injurious to the conduct of Canada's ability to conduct like international relations, international affairs, preventing hostile activities. Generally, in the immigration context, where you will see redactions most is in the context of security investigations, for example, or investigations involving, say, determining whether a document was fraudulent. If you're seeking judicial review, that type of information generally will be disclosed at the judicial review stage, but not in an Access to Information Act request. And sometimes you'll even see where it'll say in the GCMS note, do not disclose under this section, but then it will still be disclosed and it will have been disclosed. So how to apply, there are several links there on how to apply and submit Access to Information Act requests. It's actually incredibly straightforward, the questionnaire. I'm not going to spend time in this presentation going through the questionnaire and saying how to complete your name or how to how to input what your email address is. The questions are all self-explanatory. What I will say is that when it comes to the end, there's a box where you can submit and say, what is it that you're requesting? And it can be helpful to request broad. So for example, sometimes, people may request a specific file that was refused or an application that was refused. And instead of asking for just that file, why not ask for someone's entire electronic immigration history with IRCC so you can see all the previous decisions that someone had? Also requesting all the previous decisions can, you may discover previous refusals that if you're a lawyer or a consultant that your client may not have told you about or things like that. So why am I even giving this presentation? Like, what's the benefit of submitting Access to Information Act requests? The main one is to obtain the actual reasons for refusal. And anyone who's had a refusal from IRCC will know that the reasons that they give do not tell the whole story. In the time that I've been practicing law, the reasons were never great to begin with that were provided in refusal letters, but they've gotten worse and worse and vaguer. And now often they'll say, for example, that someone's temporary resident visa application was refused because they weren't satisfied that they met the requirements for a temporary resident visa. It says nothing. And by doing an ATIP request, you can see the Global Case Management System. I think I've used that acronym in this presentation without saying what that stands for. That's the Global Case Management System, or IRCC's internal notes. So here's an example, and the slide is unfortunately going to be small, and it might not show up clearly on YouTube, but what you can see on the left here are the checklist reasons for refusal from the Beijing Visa Office. And it lists a whole bunch of factors that may have been considered in refusing the application. The applicant would not really know in a subsequent application how to address these reasons for refusal. This, in this square, is the detailed reasons for refusal that are found in the internal notes. And these internal notes may be in the subject of a different presentation. I can get into how they're also increasingly becoming vague through the use of a processing tool called Chinook. But for the most part, it still is more detailed than the checklist reasons for refusal, and it often is more detailed. So for example, in this, it says, the person has no immigration record with IRCC. They're a 24-year-old female. They completed a 2-year course in hospitality management. They have 6 months caregiver training. The application states that the mother is a caregiver and the father is a business owner, but there's no evidence of their employment. The subject did not provide sufficient demonstration to show level of establishment in the Philippines in this case. They haven't taken higher studies and completed a bachelor's degree in 2010. There's similar courses in their country of residence. This would have been a study permit refusal. And as you can see, it's much more detailed what is provided in the internal reasons that often can only be accessed through Access to Information Act request or judicial review. The other benefit can be to learn the status of processing. If there are delays in your application and you're wondering what's going on, then it's possible that the GCMS notes may contain notes that have concerns that have not yet been shared. The other context where it can be useful to request the full physical file, which is a copy of the application, any emails that are on the file, any notes that the officer has, is that they may contain issues that you can preemptively address. This has become a little less common ever since applications started moving online. And I gave an example here of one case, one of my cases, where we submitted a access to information request for the full file due to delays in processing. And this was back in the days of paper files. And what we discovered was, we get back copies of all the forms that we had submitted in the application. And what we saw was a post-it note that a visa officer had put on one of the forms, which said that they had concerns about the validity of a marriage certificate that was in the application. And we wound up submitting essentially a response to the post-it note, I think was what we called it. IRCC had never contacted us about the concern. The file was delayed, and we wound up providing submissions about the post-it note to move the file along, which we would never have learned had it not been for the Access to Information Act request. This is another one up here, a GCMS note, which showed that a visa officer had concerns about an employment letter and the person's role at the company, And the person did not get a procedural fairness letter, but because the person we had submitted the Access to Information Act request, they were able to respond to this concern before the officer even sent it. Now, there are delays in obtaining Access to Information Act request results. Part of this is due to the number of requests. As I mentioned, I originally gave this presentation in 2022, and so the numbers are current for there. But what you can see is from 2018 to 2022, a substantial increase in the number of Access to Information Act requests. Beyond personal information and files, it's also possible to request policy manuals, training materials, things like that. Those who follow me on Twitter know that I post a lot of internal government documents that are obtained through ATIPs, and it can be useful. So some of the two examples back in, I believe, 2022, express entry draws seemed to stop, and I actually even didn't do this ATIP request. Someone sent me an ATIP request that they did, where they had obtained a memo from the minister which showed that the department was going to be pausing express entry draws. And it was useful to see this because it provided some context to what was going on. Similarly, when the department switched to the 2022 NOC codes from 2016, a different memo that I had published posted which NOCs were going to be negatively and positively impacted, and it was useful to learn this ahead of time as well. You can also request data about approval rates for different visa offices. And training manuals that the visa officers use. These could be useful both to teach yourself about the law, because IRCC does very comprehensive training of its officers. It can also be used in files or judicial reviews. I had one judicial review that was in 2023, I believed, where I had obtained training materials for the processing of study permits, and I had discovered that IRCC has a policy, or at least a specific visa office, or at least just one manual, had a policy that they would not misrep children who are the principal applicants in study permits. I used that in the context of a judicial review, and it wound up being, I wouldn't say determinative to the decision, but it was cited by the justice in the case, and I do think it was helpful. So getting these training materials can be very useful. Finally, issues that you'll experience as you're going through submitting Access to Information Act requests is, and the big one is, does knowing any of this matter? Does it make you a better applicant or a better lawyer or a better consultant? I think that certainly the internal notes is essential. I don't know how people represent clients if they aren't submitting Access to Information Act requests. Whether knowing the internal policies matters or not, I read a lot of them. I go back and forth with myself about whether it's that effective a use of time as well. But I do tweet and I do share what I think are the most valuable tidbits that I've pulled out of it. And I do just have an interest in it. The other area that is being learned through Access to Information Act requests is the department's use of artificial intelligence, which includes advanced analytics, Chinook, Lighthouse or Watchtower, which will be the subject of a separate video. But understanding those systems can be helpful in at least knowing the visa processing methods of the department. I'm not sure, again, how it helps in preparing necessarily an application, but at least you understand the process that you or your client will be going through. So same thing, here's a specific example where I obtained through Access to Information Act request materials and emails from the New Delhi visa office, which said that in order to send a message to the community, in quotes, they were going to start pursuing misrepresentation against Indian applicants wherever possible. Does knowing that visa office has a policy of that help an application, help an applicant or their lawyer or consultant? And I'll let you be the judge. I'm not sure there's a right answer or not. And where it could also be helpful, and I think the slide might be cut off by my face, is just whether there's inconsistent processing based on officer compared to visa stats, whether, kind of knowing the overall visa stats, I guess, can help you know what you or your client might be expecting. So that's a short video that I've prepared for the firm's YouTube channel on submitting Access to Information Act requests. I hope to do more videos like this. Please leave your thoughts in the comments. You can like and subscribe to the firm's YouTube channel. And my email is there as well if you have any questions. Thank you.